What you know, Alibis? Welcome to another episode of Pretty Lies and Alibis. I'm Gigi. It's Friday, June 27th. Hope you guys have had a good day so far. It's going to be a little late when I get this out, but I just got some new documents in the Kouri Richins case. She has been hit with 26 new charges, and I have the documents, so let's jump in. First off, there are 5 counts of mortgage fraud, and that is a second-degree felony. Instead of reading these individually, we're just going to break down the dates that this happened. June 29th, August 2nd, August 12th, October 13th, and November 23rd of 2021. And it says, in Summit County, state of Utah, the defendant did with the intent to defraud, knowingly make any material misstatement, misrepresentation, or omission during the mortgage lending process, intending that it be relied upon by a mortgage lender, borrower, or any other party to the mortgage lending process. The value of the property, money, or thing obtained or sought to be obtained is or exceeds $5,000. Next up, 5 counts of forgery. This is a third-degree felony. The dates, all in 2021, June 29th, August 2nd, August 12th, October 13th, and November 23rd. In Summit County, state of Utah, the defendant did with the purpose to defraud someone, make, complete, execute, authenticate, or utter a writing so that the writing or the making, completion, execution, authentication, or utterance purports to be the act of another person, whether that person is existent or non-existent. Next up, 7 counts of issuing a bad check, all in 2021, August 28th, October 12th, November 11th and 12th, twice on December 20th and December 22nd. In Summit County, state of Utah, the defendant did issue or pass a check for the payment of money for the purpose of obtaining from any person, firm, partnership, or corporation any money, property, or other thing of value, or paying for any services, wages, salary, labor, or rent. She has 7 counts of issuing a bad check. Those are second-degree felonies. The dates, all in 2021, August 28th, October 12th, November 11th, November 12th, twice on December 20th, and December 22nd. In Summit County, state of Utah, the defendant did issue or pass a check for the payment of money for the purpose of obtaining from any person, firm, partnership, or corporation any money, property, or other thing of value, or paying for any services, wages, salary, labor, or rent. The defendant knew the check would not be paid by the drawee. Payment was refused by the drawee. The check made or drawn in the state of Utah is or exceeds $5,000. 3 of these, the amount is or exceeds $5,000. Those are second-degree felonies. And 4 of these are at the is or exceeds $1,500 but is less than $5,000. Those are third-degree felonies. 7 counts of money laundering. That is a second-degree felony. The dates for these in 2021, August 27th and 28th. October 12th through the 14th, 2 counts for November 10th through the 16th, December 23rd, another for December 23rd and the 24th, and a separate one for December 24th. In Summit County, state of Utah, the defendant did conduct a transaction knowing that the property involved in the transaction represents the proceeds of some form of unlawful activity with the intent to promote the unlawful activity. She has 1 count of communications fraud. That is a second-degree felony. This happened on January 11th, 2022 in Summit County, state of Utah. The defendant did devise a scheme or artifice to defraud another or to obtain from another money by means of false or fraudulent pretenses, representations, promises, or material omissions, and communicated directly or indirectly with any person by any means for the purpose of executing or concealing the scheme or artifice. The value of the property, money, or thing obtained or sought to be obtained is or exceeds $5,000. Lastly, one count of pattern of unlawful activity. That's a second-degree felony. It has the dates for this between on or about June 29th, 2021 and March 3rd through 4th, 2022. In Summit County, state of Utah, the defendant did commit prohibited conduct concerning a pattern of unlawful activity by receiving proceeds derived, whether directly or indirectly, from a pattern of unlawful activity in which the defendant has participated as a principal. They have a section that is the background. The defendant met Eric Richins in 2009 while she was working as a cashier at Home Depot. They had a child in 2012 and married in 2013. At the time of the marriage, Eric Richins and his business partner owned a successful stone masonry business called C&E Stone Masonry LLC. Eric Richins and the defendant entered into a premarital agreement whereby the defendant released and relinquished all right, claim, or interest in C&E Stone Masonry LLC. The premarital agreement provides that following Eric Richins' marriage to the defendant, C&E Stone Masonry shall nevertheless remain the sole property of Eric Richins. The premarital agreement further provides that the defendant shall have no right or claim to the business except that if Eric Richins should die prior to the defendant while the two are lawfully married, Eric Richins' partnership interest in the business shall transfer to the defendant. In early 2019, the defendant used a power of attorney to obtain a $250,000 home equity line of credit, otherwise known as a HELOC, on Eric Richins' premarital home without his knowledge. On April 26, 2019, the defendant formed K. Richins Realty LLC for the purpose of selling and buying real estate. The defendant was the sole member of the company. The defendant used the proceeds from the HELOC to initially fund K. Richins Realty and hard money loans to finance its ongoing operations. Eric Richins first learned of the HELOC in October 2020. The secret origination and continued existence of the HELOC was a source of tension between the defendant and Eric. The defendant informed Eric that she would repay the loan and led Eric Richins to believe she had repaid it. The HELOC was not paid off on the day of Eric Richins' death. October 13th, 2020, Eric Richins consulted an estate planning attorney. Eric informed his lawyer he wanted to protect himself in the short term from the recently discovered and ongoing abuse and misuse of his finances by the defendant and to protect his 3 children in the long term by ensuring the defendant would never be able to manage his property after his death. On November 3rd, 2020, Eric Richins executed several estate planning instruments, including a health care directive, durable power of attorney, pour-over will, and the Eric Richins Living Trust. In each of these instruments, he appointed his sister, Katie Richins Benson, his agent or trustee, to the intentional and purposeful exclusion of the defendant. He transferred his home and his interest in C&E to the trust. Eric removed the defendant as the beneficiary of a $500,000 New York Life Insurance Company policy on his life and designated the trust as the beneficiary. The defendant did not understand this estate plan until after Eric Richins' death. In the 5 months prior to Eric's death, K. Richins Realty realized $170,000 in revenue while its monthly debt service exceeded $250,000. It borrowed from over 25 lenders to support itself and service its debt obligations. Despite K. Richins Realty's existing debt and insufficient revenue, the defendant continued to use hard money loans to purchase 3 additional properties in November 2021. When the defendant closed on the 3 properties on November 30th, 2021, she added $1.1 million in high interest debt to her already staggering and unserviceable debt load. By that day, she had already defaulted on 1 loan and was delinquent on several others. She continued efforts to borrow from the new high interest lenders to meet her existing obligations. By the end of 2021, the defendant stood on the precipice of total financial collapse. On December 23, 2021, the defendant contracted to purchase an unfinished mansion in Midway, Utah, using $2.9 million in high-interest debt due in 6 months, even though she lacked the financial ability to service the additional debt, refinance the debt, rehabilitate the property, or otherwise dispose of the property. The defendant was scheduled to close on the property on March 4, 2022, the day of Eric Richins' death. She ultimately closed on it the next day. On the day of Eric's death, K. Richins Realty owed hard money lenders at least $1.8 million, and the day after Eric's death, it owed them nearly $5 million. Holy moly. At the time of Eric Richins' death, at least 3 insurance policies on Eric's life existed, with death benefits of $1,350,000 and the defendant as the beneficiary. A 4th policy existed with a death benefit of $500,000. The defendant mistakenly believed that she was the beneficiary of that policy as well. A 5th policy existed that paid approximately $168,000 towards the balance of Eric's mortgage. At the time of his death, Eric's estate was worth approximately $5 million. The defendant, her family, K. Richins Realty, and C&E banked with America First Credit Union. The defendant also had a personal checking account with Navy Federal Credit Union, which included a $15,000 line of credit. They list the counts here. It says the defendant submitted a falsified bank statement to Iron Bridge Financial in support of a mortgage loan application. On July 7th, 2021, the defendant, on behalf of K. Richins Realty, entered a mortgage loan with Iron Bridge Financial. On June 29th, 2021, in support of the loan application, the defendant submitted a purported America First statement for K. Richins Realty dated May 31st, 2021, showing an account balance of $210,898.61. The actual America First statement dated May 31st, 2021, shows an account balance of $15,609.93. C&E's America First statement dated May 31st shows an account balance of $210,898.61. The transaction descriptions listed on the purported statement that the defendant submitted in support of the mortgage loan application are identical to the transaction descriptions listed on C&E's statement. That would be Eric's business. The purported statement the defendant submitted is compromise of the header of K. Richins Realty's actual statement and the body of C&E's statement. On July 2nd, 2021, while processing the mortgage loan, an Iron Bridge representative noted to the defendant, "When I ran your credit, it was lower than I expected. Looks like there are some delinquencies with regards to a few credit cards. I was just a bit surprised by that. I know you have a lot of money in the bank to cover expenses." 3 days later, the defendant explained, "I recently learned about all of this as well, LOL. And then my husband tried to explain to me this was his doing a while ago. We're in the process of separation for one of many reasons, but this is one of them to keep it short and sweet, LOL. It's been crazy to say the least. There is no evidence to suggest that this explanation is true." The next section, the defendant submitted a falsified bank statement to Boomerang Finance in support of a mortgage loan application, and they list the 3 counts that are associated with this. August 4th, 2021, the defendant, on behalf of K. Richins Realty, entered a mortgage loan with Boomerang Finance. On August 2nd, 2021, in support of the loan application, the defendant submitted a purported America First statement for K. Richins Realty dated June 30th, 2021, showing an account balance of $702,831.96. K. Richins Realty's actual America First statement dated June 30th shows an account balance of $15,339.12. C&E's America First statement dated June 30th shows an account balance of $702,831.96. And they say the purported statement the defendant submitted is compromised of the header of K. Richins Realty's actual statement and the body of C&E statement. In August of 2021, she applied for a mortgage loan with Excel Financial Services. And again, for her business, she showed an account balance of $694,730.15. Her actual statement dated August 1st, 2021, shows an account balance of $1,893.94. C&E's, of course, showed that $694,730.15 balance. Excel's representative asked the defendant for a letter explaining her low credit rating. On September 12, 2021, the defendant wrote that her low credit rating was because of a lady out of Seattle that had gotten a hold of her Social Security number. There is no evidence to suggest this explanation is true. Again, October 13th, 2021, she submitted another America First statement for her personal account dated September 30th, 2021, showing an account balance of $169,442.28. Her actual statement dated October 1st showed a balance of $4.01. However, you guessed it, C&E's America First statement from September 30th of 2021 shows that balance of $169,442.28. On November 23rd, 2021, in further support of the loan application, the defendant submitted a purported K. Richins Realty America First statement dated October 31st, 2021, showing an account balance of $57,811.42. K. Richins Realty's actual statement dated October 31st shows an account balance of $1,684.75. K. Richins Realty's statement dated August 30th, 2021 shows an account balance of $57,811.42. The transaction descriptions listed on the purported statement that the defendant submitted in support of the mortgage loan application are identical to the transaction descriptions listed on K. Richins Realty's August statement. The statement she submitted is comprised of the header of K. Richins Realty's October statement and the body of its August statement. Next section, the defendant issued a series of bad checks and laundered money. They list the counts. On August 28th, 2021, the defendant wrote check number 271 from her Navy Federal account to K. Richins Realty for $2,100. At the time, the Navy Federal account balance was zero, and the line of credit was $13,694.50. The defendant deposited the check into K. Richins Realty's America First account. At that time, the America First account balance was $9,139.23. The defendant then transferred $2,500 from the America First account to her mother and $13,775.85 to several creditors before America First could draw back the $2,100. America First ultimately returned the check for insufficient funds. October 12th, 2021, she wrote a check from her Navy Federal account to the Realty account for $2,500. At the time, Navy Federal account balance was zero, and the line of credit $14,952.22. She deposited the check into the Realty's America First account. At the time, the America First account balance was $505.49. She then transferred $2,518.10 from the America First account to several creditors before America First could draw back the $2,500. That check was returned for insufficient funds. November 11th, she wrote a check from her Navy Federal account to the Realty for $3,000. Again, the Navy Federal account balance was zero, and that line of credit, $14,981.22. She deposited the check into the Realty's America First account. At the time, the America First account balance was $2,231.39. She then transferred $1,000 from the America First account to her mother and $2,000 to her personal account before America First could draw back the $3,000. It was returned for insufficient funds. On November 12, 2021, the defendant wrote check number 275 from her Navy Federal account to the Realty for $5,000. At the time, the Navy Federal account balance was zero, and that line of credit, $14,981.22. She deposited the check into the Realty's America First account. At the time, that America First account balance was $575.39. She transferred $1,000 from the America First account to her mother and $2,000 to her personal account before America First could draw back the $5,000. It was returned for insufficient funds. December 20th, 2021, she wrote a check from Navy Federal to herself for $4,000. At the time, the Navy Federal account balance was $51.41. Line of credit, $14,565. She deposited the check into her personal America First account. At the time, the America First account balance was $586.76. She then transferred $2,215 from the America First account to her mother before America First could draw back the $4,000, and that check was returned for insufficient funds. On December 20th, 2021, the defendant wrote check number 294 from Navy Federal to herself for $10,000. At the time, the Navy Federal account balance was $51.41. Line of credit, $14,565. She deposited the check into K. Richins Realty's America First account. At that time, the America First balance was $1,133.99. She then transferred $9,592.33 from the Business America First account to several creditors before America First could draw back the $10,000, and that was returned for insufficient funds. December 22nd, 2021, she wrote a check from her Navy Federal account to herself for $10,000. At the time, Navy Federal's balance was $51.41. The line of credit was $14,565. She deposited the check into her personal America First account. At that time, the account balance was $998.24. She then transferred $10,000 from her personal America First account to her family's America First account before they could draw back the $10,000, and the check was returned for insufficient funds. I can't even imagine how exhausting it must be to be robbing Peter to pay Paul all the time like this. Crazy. Next section, the defendant fraudulently extracted $45,000 from her best friend. In late 2021, K. Richins Realty owned a home located at, and it tells the address, on which the defendant owed $456,500 in 4 short-term, high-interest, hard money loans. 3 of the 4 notes secured by this property matured on January 7th or 8th, 2022. Beginning in October 2021, the defendant unsuccessfully tried to refinance the address into a traditional 30-year mortgage. She planned to then sell or finance the property for her best friend. The best friend, her husband, and 3 small children moved into the home. The defendant and her best friend signed a residential lease agreement with option to purchase, wherein the best friend agreed to pay the defendant $2,900 per month in rent with an option to buy the home for $490,000. On January 11th, 2022, the defendant's best friend caused 2 wires totaling $45,000 to transfer into K. Richins Realty's account. Correspondence between the defendant and her best friend establishes the defendant agreed to apply this money as a down payment on a long-term mortgage, supposedly closing January 18th, 2022. Immediately prior to the best friend's wires entering K. Richins Realty's account, The account balance was $1,996.68. As soon as the first wire entered the account and before the second wire entered the account, the defendant transferred $19,299 of her best friend's down payment to her personal account to cover a wire transfer of exactly $19,299 to Fund Fee, an entity by which the defendant had taken out a high-interest accounts receivable loan unrelated to the property her best friend was living in. By January 19th, 2022, the defendant had spent the remainder of her best friend's $45,000 down payment on expenses unrelated to the home. On January 19th, 2022, K. Richins Realty's account balance was $227.69. And the home's refinancing did not take place in January 2022. The defendant was forced to enter into an extension agreement with the largest of the four hard money lenders on January 26, 2022. The 30-year mortgage lender revoked the proposed loan in mid-February and offered less affordable terms. The defendant was thus forced to enter into another extension agreement with the largest hard money lender on February 16, 2022. The unpaid principal balance on that date was $347,715.86, and the extension agreement extended the repayment term to March 8, 2022, 4 days after Eric Richins' death. Ultimately, one of the defendant's lenders foreclosed on the property and evicted the defendant's best friend and her family. The next section, the defendant submitted a falsified insurance application on Eric Richins' life. On January 29th, 2022, the defendant applied to TrueStage for an insurance policy on Eric's life with a death benefit of $100,000, and the defendant named as the beneficiary. This life insurance policy became effective on February 4th, 2022, 10 days before her attempt on Eric's life and 1 month before his death. The defendant was able to apply for the policy because of her membership in PenFed Credit Union. Eric had no affiliation with PenFed. The policy premiums were deducted from K. Richins Realty's America First account. Eric had no affiliation with this account. The address for Eric provided on the application is a P.O. box solely belonging to the defendant. The phone number for Eric provided on the application contained an incorrect digit. The signature on the application that purported to be Eric Richins' signature is a forgery. Next section. The defendant attempted to murder Eric Richins for a pecuniary gain. The defendant occasionally employed Hayden Jeffs to assist her with renovating houses. On January 20th, 2022, she messaged Mr. Jeffs, "I did want to chat with you about something super random. Not now, at kids' stuff. I'll call you tomorrow if that works." On January 21st, 2022 at 7:24 p.m., the defendant texted Mr. Jeffs, "Hey, today snuck away from me. Can I give you a call in the morning around 11:30? The next day, January 22nd at 11:06 a.m., she messaged Mr. Jeffs, "Got a sec." Mr. Jeffs told law enforcement he spoke with Kouri on January 22nd, and she asked him for fentanyl. The defendant told Mr. Jeffs she wanted the fentanyl for a client who had back pain. Mr. Jeffs told the defendant he would not get her fentanyl, and the defendant hung up on Mr. Jeffs. January 22nd, 2022 at 5:35 p.m., after the phone call in which Mr. Jeffs declined to get fentanyl for the defendant, she texted Mr. Jeffs, "Have another one for you. Call me if you get a sec." Mr. Jeffs told law enforcement that during a second phone call with Kouri on January 22nd, the defendant asked him for propofol. Mr. Jeffs told the defendant he could not get her propofol. Text messages from January 22nd between Kouri and Mr. Jeffs were mutually deleted from the defendant's phone. After that date, the defendant and Mr. Jeffs did not communicate ever again. Kouri and Mr. Jeffs had communicated on a regular basis throughout the prior year. On May 31st, 2022, approximately 3 weeks after the defendant's arrest for the murder of Eric Richins, The defendant's mother messaged the defendant, Mr. Jeff's running his mouth. The defendant occasionally employed Carmen Lauber to clean houses. Ms. Lauber told law enforcement that sometime in early 2022, before Eric's death, Kouri either called or texted to ask that she procure some fentanyl for the defendant. A forensic analysis of Verizon's records for Kouri's cell phone shows 746 SMS messages, 94 MMS messages, and 12 calls between the defendant's phone and Ms. Lauber's phone between January 1st, 2022 and March 15th, 2022. The messages were manually deleted from Kouri's phone. Her phone contained messages to and from Ms. Lauber before and after this time frame. Ms. Lauber told law enforcement that pursuant to the defendant's request for fentanyl, she contacted Nicole Cummins for an introduction to someone that would sell her fentanyl. Ms. Cummins confirmed that Ms. Lauber asked her for an introduction to someone that would sell Ms. Lauber fentanyl. Ms. Cummings elaborated that Ms. Lauber messaged her through Facebook asking to speak with her and that she called Ms. Lauber shortly thereafter. A Facebook message from Ms. Lauber to Ms. Cummings on February 5th, 2022 at 1:37 p.m. asked, "Text me. I've got a question. Won't do it on this." In response to Ms. Lauber's inquiry, Ms. Cummings provided Ms. Lauber with the phone number of a fentanyl dealer, Robert Crozier. Ms. Lauber's phone contains a contact for Mr. Crozier's phone number. The contact is labeled in a fashion that connects Ms. Cummings with Mr. Crozier. Ms. Lauber told law enforcement she contacted Mr. Crozier shortly after receiving his contact information from Ms. Cummings and asked to purchase fentanyl. Ms. Lauber's phone records established she texted Mr. Crozier on February 10th, 2022 at 8:52 p.m. She told law enforcement she met him at the Maverick gas station in Draper on February 11th, 2022, and purchased 15 to 30 round light green-blue pills, which she understood to be fentanyl. Ms. Lauber's phone data shows that she called Mr. Crozier several times on February 11th between 5:19 and 6:52 p.m. Ms. Lauber stated these calls were to coordinate the specific timing of the fentanyl purchase. Her phone data also showed she texted him several times at 7:18 p.m. while she was located at the Maverick. Her phone data shows several text messages between Kouri and herself on February 11th, 2022. They began at 3:42 p.m. while Ms. Lauber was at her home in Heber and continued until 6:23 as she passed through Linden on her way to the Maverick gas station in Draper. The defendant and Ms. Lauber texted at 7:18 p.m. while Ms. Lauber was located at the Maverick and text messaging with Mr. Crozier. The messages continued at 8:20 p.m. as Ms. Lauber passed through Lehigh on her way back to her home in Heber and concluded at 8:56 p.m. while she was at her home in Heber. Ms. Lauber told law enforcement she delivered the pills she purchased to the defendant in a hand-to-hand transaction in the driveway of Ms. Lauber's home in Heber on either February 11th or February 12th, 2022. Her phone data shows, in addition to the text messages Kouri and Ms. Lauber exchanged on February 11th, they also exchanged text messages on February 12th at 9:58 a.m. and 2:49 p.m. A certain diner in Camas, Utah opens daily at 7 a.m. At 8:53 a.m. on February 14th, 2022, Kouri placed a 1-minute phone call to the diner. The defendant and Eric's joint bank account statement shows a $41.29 purchase at the diner on this day. At 9:41 a.m., the defendant messaged her paramour, headed that way. At 9:49 a.m., she texted him a screenshot of a navigation app on her cell phone showing her current location on SR 32 in Camas and her projected arrival at an unknown destination at 10:49 a.m. At 11:09 a.m., Eric placed a 2-minute call to Kouri. At 11:27, he texted a photograph to Kouri. That photograph has been deleted from both the defendant and Eric's phones. At 11:33 a.m., Eric texted Kouri, "I'm going to go lay down for a bit. If I don't start getting better, I'm going to head to the hospital." 1 minute later, the defendant responded, "Geez, is that bad? Need me to come home? Go take a nap and call me when you're up." 5 minutes later at 11:39 a.m., activity recorded on Eric's phone and associated devices ceased. Activity did not resume until nearly 2 hours later at 1:32 p.m. At 1:43, Eric texted Kouri, "Are you home?" Kouri responded, "No, in Provo, waiting on my cabinet installer guy. Are you home?" At 1:45, Eric responded, "In the office. I've been sleeping out here." Eric's office was in a freestanding structure behind his home. At 1:59 p.m., Eric called Kouri Wright, a close friend. Mr. Wright could hear fear in Eric's voice and could tell that Eric was scared. At 2:11, Eric Richins called Josh, another close friend. The friend was struck by the tone of Eric's voice and said he seemed a little different, down, and somber. Opioids, including fentanyl, can cause allergic and pseudo-allergic reactions, to include hives. Eric did not have any food allergies. Kouri and Ms. Lauber exchanged 30 text messages on Valentine's Day 2022. On June 18, 2022, 3.5 months after Eric's death, the defendant texted her best friend about this incident. She wrote, "It was Valentine's Day and Eric and I were both working from home that day. I ordered lunch from the diner. He never broke out in hives or used an EpiPen. I was effing with him. He said the sandwich hurt his stomach, so he was going to take a nap. No hives, no EpiPen." On August 22nd, 2023, nearly 4 months after Kouri was arrested for the murder of Eric, she discussed this incident in 2 phone calls. In a phone call with her mother, Kouri confirmed she was the person who picked up sandwiches from the diner on Valentine's Day. She said, "We ate in the office." In a phone call with her brother, she discussed buying lunch at the diner that day. The next section, she murdered Eric Richins for monetary gain. Ms. Lauber told law enforcement in late February 2022, Kouri told her that the fentanyl pills she previously provided were not strong enough and asked she procure something stronger, some stronger fentanyl. Ms. Lauber initially stated Kouri specifically asked for some of the Michael Jackson stuff during the second request for fentanyl, but subsequently conceded the defendant may have referred to Michael Jackson during her earlier request for fentanyl. Michael Jackson died of a propofol overdose. On February 26, 2022, Ms. Lauber sent Ms. Cummings a Facebook message asking Ms. Cummings again provide her with Mr. Crozier's phone number. Later that same day, Ms. Lauber contacted Mr. Crozier and arranged to purchase additional fentanyl from him at the same Maverick gas station in Draper. Ms. Lauber's phone data shows on February 26, 2022, beginning at 2:25 p.m., Kouri and Ms. Lauber exchanged several text messages. They continued to exchange text messages between 5:01 and 10:22 p.m. as Ms. Lauber traveled from her home in Heber to the Maverick gas station in Draper and then back to her home in Heber. Ms. Lauber's phone data also shows she exchanged texts with the defendant and Mr. Crozier while she was located at the Maverick. March 4th, 2022 at 3:21 a.m., Kouri called Summit County Dispatch and reported her husband Eric was not breathing and he's cold. He doesn't have a pulse. 10 minutes later, Summit County EMS personnel and the sheriff's deputies arrived at the Richins home. They found Eric on the floor at the foot of his bed and performed life-saving measures, but ultimately declared him deceased at 4:58 a.m. EMS personnel thought he had been dead a while and noted he was asystole the whole time. Asystole means you are dead. You have no electrical activity in your heart, no pulse, no cardiac output. While EMS personnel were attending to Eric, the defendant told law enforcement she and Eric had a drink together at 9 o'clock to celebrate something at work tomorrow. A year later, Kouri told law enforcement, "I made Moscow mules in the kitchen and I brought them into our bedroom." The defendant further said they drank sitting on the bed. Sometime after Eric's death, Kouri wrote in a journal that on the night of Eric's death, she and Eric went to the kitchen and both started grabbing ingredients for the drink and a lemon drop. We finished talking, made our way back to our bedroom, and brushed our teeth. A pathologist at the office of the medical examiner performed an autopsy on Eric and concluded his immediate cause of death was drug intoxication, fentanyl. He had 5 times the lethal dose in his blood, and his gastric fluid contained additional levels of fentanyl. The medical examiner determined the byproducts of the fentanyl found in Eric's gastric fluid were typical of illicit fentanyl, not medical-grade fentanyl. The medical examiner determined the fentanyl found in Eric's body had been orally ingested. The medical examiner also found 16,000 ng or milliliters of quintiapine in Eric Richins' gastric fluid. That is an atypical antipsychotic medication used for the treatment of schizophrenia, bipolar disorder, and major depressive disorder. It's widely used as a sleep aid due to its sedating effect. The defendant told law enforcement at the time of Eric's death she had a prescription for the medication. On the night of Eric's death, Kouri told law enforcement, "We eat THC gummies. Sometimes Eric will eat a gummy before he goes to bed. He didn't. It didn't seem like he did, though." A year after Eric's death, she told law enforcement she saw Eric take a THC gummy in the bedroom after drinking. The defendant then clarified, "I didn't actually see him take it. He told me he took it, and then he had to have taken it while I was making the drinks." In explaining to law enforcement how the defendant thinks the fentanyl got into Eric's body, she said, "I honest to God think it was in one of those gummies, 100%. After her arrest for the murder of Eric, the defendant's mother asked if she was sure the fentanyl came from a THC gummy. The defendant replied, "That is what I'm banking on, yes." The OME did not find any THC in Eric's blood or gastric fluid. The state toxicology lab tested the THC gummies in Eric's home at the time of his death and determined they did not contain fentanyl. She told law enforcement she went to bed with Eric in the bedroom at approximately 9:30 to 9:45 on March 3rd, 2022, and shortly thereafter went into one of their children's bedrooms to sleep with the child because the child was having nightmares. She said she awoke in the child's bedroom at approximately 3 a.m. on March 4th and returned directly to the bedroom. She said she was asleep in the child's bedroom the entire time. She told law enforcement when she left their bedroom at approximately 9:30 to 9:45 to go to the child's bedroom, she left her cell phone plugged in next to her bed and did not take it into the child's bedroom. She told law enforcement upon returning to their bedroom, she felt Eric and he was cold to the touch and not breathing, and she immediately dialed 911. Her 911 call was received at 3:21 a.m. on March 4th. Forensic analysis of her cell phone shows it was unlocked 6 times between 3:06 a.m. on March 4th, 2022, and 15 minutes later at 3:21 when the defendant called 911. The analysis also shows in the 13 minutes between 3:08 and 3:21 a.m., Kouri's phone or an associated device traveled approximately 378 feet. She used several cell phones, including burners. The cell phone she primarily used leading up to and shortly after Eric's death indicates a significant amount of information was manually deleted from it, particularly between January and mid-March 2022. Forensic analysis of one of her cell phones show that by April 16, 2022, 3 days after law enforcement first informed her that Eric died of a fentanyl overdose, her phone was used to access website articles with the following titles, among others: Timpanogos Women's Facility, What Happens to Deleted Messages, Cause of Death Usually Does Not Impact Life Insurance Payment, How Do Police and Forensic Analysts Recover Deleted Data from Phones, and Signs of Being Under a Federal Investigation. Forensic analysis of that same cell phone also shows that by June 6, 2022, her phone was used to conduct the following internet searches, among others. Can you delete everything off an old iPhone without actually having it? Women's Utah prison. Can cops uncover deleted messages? iPhone. Can cops force you to do a lie detector test? If someone is poisoned, what does it go down on the death certificate as? How long does life insurance companies take to pay? And what is a lethal dose of fentanyl? On May 8, 2023, she was arrested for the murder of Eric and received a copy of the charging document and probable cause statement. The probable cause statement referred to Ms. Lauber by her initials and contained many of the facts presented above. On a jail call that day with her mother and brother, Kouri said Eric asked me to ask Miss Lauber for pain pills. Kouri never mentioned asking for pain pills for Eric or for Ms. Lauber during the 3 hours of police interviews, and indeed insisted Eric never took illicit drugs or pain meds other than occasional over-the-counter pain medication. Next section, the defendant fraudulently claimed insurance benefits from Eric's death. She was the beneficiary of 2 insurance policies on Eric's life issued by True Stage with a death benefit of $350,000. One of the policies issued on May 12, 2017, and the other February 4, 2022, 1 month prior to Eric's death. On April 28, 2022, she submitted a claim against the policies. On June 7, 2022, True Stage learned Eric's cause of death was drug intoxication fentanyl. On June 14th, True Stage left a voicemail with the defendant requesting a copy of any prescription Eric had for fentanyl. Later that same day, she informed True Stage the fentanyl was not prescribed and she didn't have any idea how Eric obtained the fentanyl. The next day, June 15th, 2022, she reiterated to True Stage she really did not know where Eric obtained the fentanyl. And the last part, the pattern of unlawful conduct is predicated upon the offenses charged in counts 1 through 25 above, and herein uncharged insurance frauds, attempted aggravated murder, and attempted murder offenses. Her trial is set for mid-February, and we will definitely be following this one. I will be going out for some of that. By the way, just a quick heads up, most likely on Sunday, if you're a Patreon member, Fruit Loop and I are going to do a live. She's coming to the beach with me, and I haven't been able to do a Patreon live. We normally do them about every week, but with the events of the last few weeks, with me being in Phoenix for Lori Daybell's trial and then Grammy getting sick, unfortunately, I haven't been able to hop on, but we are going to get on there and hang out. There are a lot of OGs in the Patreon, so it should be really, really fun. And later on, we'll probably do some kind of a Daybell wrap up together. We'll probably record that, but I'll keep you posted. All right, that is it for now. Hope you guys have a good rest of your weekend, and we will see you soon.